The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. Thanks again for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video, we're going to discuss the process of setting up a guardianship in Iowa for a disabled adult. We'll briefly discuss the role of guardians in Iowa, who acts as the petitioner, and what information should be included in the petition. Then we'll take a look at how the courts in Iowa determine if guardianship is necessary. Finally, we'll discuss what paperwork is necessary, who should be involved in the process, and what comes after the hearing. So what exactly is a guardian? So a guardian, as opposed to a conservator, deals with non-financial issues for a disabled adult. In Iowa, if someone's decision-making capabilities become so impaired that they are unable to adequately maintain their own health, they will typically require some degree of guardianship. In order to set up a guardianship, the court must decide the level of competence in the proposed respondent. The respondent is the person who may or may not need a guardian. Similar to the civil litigation cases, there must be clear and convincing evidence of the necessity for a guardian. Also, under Iowa law, a full or a plenary guardianship is only to be set up when absolutely necessary. Whether the guardianship should be limited is also decided by the courts under Iowa law. The petitioner for the guardianship is usually someone other than the respondent, possibly a family member, friend, or someone else that believes the respondent needs help. However, a person can file their own petition for guardianship for themselves. It's important to have all the pertinent information in front of you when filling out the petition form. Information needed in the form is going to include things like statements explaining the factual basis for the petition, why there is no less restrictive option than a guardianship, names and addresses of all the pertinent parties involved, including the proposed guardian, and statement detailing why he or she should be selected. Also, a list of names and addresses of the respondent's family members, physicians, and institutions wherein the respondent was treated at least 6 months prior to filing. Also, any names of other pertinent legal representative or payee of the respondent. So, along with the petition, the respondent is required by law to receive a written notice that details the respondent's right to be represented by an attorney, whether private or court appointed, knowing that having a guardian will take some rights away from the respondent. Also, the guardian's authority with or without prior court approval. And then after the petition has been filed, the respondent should also receive a notice of the case, including a copy of the petition and a notice telling the respondent he or she has 20 days to file an answer. So, when hearing the court case, the court will want to know specific examples of how the respondent has acted against his or own self-interest in the past and how these examples necessitate a guardian. Information such as the most recent psychological reports, medical exams, evaluations, current treatment plans, and any other pertinent assessments are all included. It is the responsibility of the petitioner to collect all this information. It also helps if the petitioner can bring along another person who can give some validity to the information, such as a physician or social worker. The court will order a professional evaluation or a court visitor if they deem it necessary to gather further information and evaluation of the potential ward. The respondent has the legal right to be at the hearing, barring any physical incapacitation or mental complication that prohibits his or her presence. In that case, the respondent can waive his or her right to be present. Generally, it is always best to have the respondent at the hearing if physically possible. This gives the judge presiding over the case a better idea of the respondent's situation, and even if there are behavioral issues that might overtake the respondent, it is best for the judge to be witness to these so as to increase the validity of the petition. Once the hearing is completed, the court will enter a written order either in favor of setting up the guardianship or dismissing the petition. If the petition is dismissed, the petitioner may appeal. If the guardianship is granted, then the guardian must follow through with a number of responsibilities, including an inventory and initial plan within the first 90 days, and complete a detailed yearly report containing all the information about the guardian's current health, living situation, contact with others, etc. As always, thank you for tuning in.
Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910, 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.